I'm going to give you some information now about the Americans with Disabilities Act. I'm going to refer to it as the ADA. The ADA applies to employers with 15 or more employees. Now, state laws against disability employment discrimination apply to those with even fewer employees. For instance, all of the employment discrimination laws in Delaware apply to companies with only 4 or more employees, which includes the owners of the business in the number of 4. Under the law, a disability is defined as a, quote, physical or mental impairment that substantially limits one or more of the major life activities of such individual, or a record of such an impairment, or being regarded as having such an impairment. Under the ADA, it's illegal to negatively change the terms of a person's employment or fail to hire someone because of disability. The law also provides that employers must attempt to make reasonable accommodations in order to permit people to do their jobs. However, this can be tricky. How does an employer determine if the employee is a person with a disability under the law? Think about these things. Does the employee have proof of a disability which impacts a major life activity like walking, learning, breathing, hearing, or fighting off disease? This is quite broad and includes some things which aren't obvious. Cancer may be a disability, so could HIV positive status, mental illness, or learning disabilities, and even a recovering addict could be a person with a disability. I will note that a person who's abusing drugs and/or alcohol at the time of the employment decision isn't a person with disability. Employers can fire people for using. But if the person has a record of a disability or the person is regarded as disabled, he's also protected by the law. For instance, if an employer learns that an employee is a cancer survivor, it's illegal to discriminate against her because of that fact. There are also cases to watch with the regarded as type of situation. For example, failing to hire someone with a limp because the management believed that the person won't be able to do the walking required, regarding the person as disabled. Basically, those hiring have to go in with an attitude of giving everyone the benefit of the doubt as to their abilities to meet the demands of the job. If they can't, then it's legal to fire them. Also, the employee must be able to perform the essential functions of the job with or without accommodations. That employee in a wheelchair, employed at the cash register, must be able to do what she's hired to do. Take money, make change, run the register, show up to work on time, etc. The accommodation would be something such as allowing her to sit all day instead of standing. So the person must have a condition that impacts a major life activity and be able to perform the essential job functions without accommodations in order to be protected by the ADA. Here are some practical tips on dealing with this law. First, each request for reasonable accommodation should be given prompt and adequate consideration by the employer. If an employee wants to change their typical duties because of a disability, the law requires that the employer engage in the interactive process. That's a term of art. It means that a request for a reasonable accommodation should be reviewed and analyzed both promptly and thoroughly. Failing to look at or answer an employee's request can be considered a violation of the law. I had a case in which an employee requested an accommodation for a learning disability, which may be an ADA disability because it impacts the major life activity of learning. She asked for hands-on training instead of written instructions. Unfortunately, her employer thought she was making excuses for her job performance. The HR director wrote an extremely damning email stating that the request was denied and telling her to just do your job. He did not even have a single conversation with the employee. He did not contact the psychologist who had done the testing for the learning disability. The company also foolishly let her go within a matter of weeks. This is retaliation, which is also illegal under the ADA. The jury awarded the employee out-of-pocket damages, punitive damages to teach the employer a lesson, and over $100,000 worth of the employee's attorney's fees. Plus, of course, it had to pay its own attorney's fees. I want to stress my advice about documentation which could be used in lawsuits against employers. Don't let managers put statements like that one into emails. Don't keep emails longer than necessary. Tell managers to delete texts with employees if not needed for the personnel file. Set up a policy that calls for regular destruction of emails or automatic deletion of certain emails. Be sure to examine the request for accommodation and how it relates to the employee's current job duties. Under the law, as I've said, a disability is defined as a physical or mental impairment that substantially limits one or more of the major life activities of such individual, a record of such an impairment, or being regarded as having such an impairment. This is not a fixed definition. For example, an individual who has a heart attack but can perform all major life activities, that is, walking, thinking, working, etc., would likely not be considered a disability under the law. A temporary condition, such as a broken leg healing normally, will not be a disability. That being said, an employer is required to assess what, if any, modifications to the employee's job duties can be provided to meet the accommodation request. Again, employees with disabilities must still be able to perform the essential functions of their jobs. Examples of possible means of providing a reasonable accommodation may include, but are not limited to, allowing more frequent breaks or periodic rest, providing modified equipment, assisting with manual labor, modifying job duties, modifying work hours or schedules, intermittent leave, employee takes off time as needed over a period of time, or providing a continuous leave of absence. If leave is provided as a reasonable accommodation, the employer can decide that the leave will run concurrently with the Federal Medical Leave Act and/or any other leave where permitted by state or federal law. This is best practice if your business can't hold open a job for more than 12 weeks. The employer should require the employee to provide a certification when requesting a reasonable accommodation. It should include the following information: the date the reasonable accommodation became medically advisable, the probable duration of the reasonable accommodation, and an explanatory statement as to the medical advisability of the reasonable accommodation. An employer should never seek genetic information in connection with requests for accommodation. That would open the employer to a claim of discrimination if the employee learns that the employer has information which might be held against him. For instance, if an employee has a genetic disorder which will likely lead to active debilitating symptoms, such as Tay-Sachs disease or sickle cell anemia, an employer does not want an accusation that the employee was let go because the employer knew that he could be debilitated in the future. All medical information received by the employer in connection with the request for accommodation should be treated as strictly confidential. I recommend keeping any medical information in a separate file, not placed in the employee's personnel file. Remember, accommodations are only required if making them does not create an unreasonable hardship for the employer. As an example, say that the requested accommodation is a 12-week leave. If the company isn't big enough to be subject to the Family Medical Leave Act, which is 50 or more employees within 75 miles, and the company can't afford to lose someone on leave for that long without replacing her, there's no duty to accommodate. Establish an internal policy for addressing requests for reasonable accommodations. The law requires fair treatment for all requests for reasonable accommodations. Establishing a clear and practical way to address all reasonable accommodation through a written policy makes it accessible to both employees and managers while eliminating uncertainty. This policy should be published in a handbook. All employees should sign off on receipt of the handbook and therefore acknowledge that they were notified of this procedure. When all else fails, call an attorney. These situations may be very complicated and involve multiple laws such as the ADA and FMLA, Family Medical Leave Act. If you're unclear as to whether your approach to a request will pass legal muster or need help establishing policies, call an employment attorney to prevent liability issues in the long term.